So we have some important news coming out of the Supreme Court's next big firearms case, which deals with ATF overreach. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a favor. I just wanted to ask you guys to double check your subscription. A lot of people have been commenting that YouTube is unsubscribing them, so just double check that. And then also, if you're not subscribed to the channel, please consider that does help the channel to grow and for these videos to get out to more people. So as I mentioned in the intro, in this video, we have some important news coming out of the next big firearms case that is going to happen in the Supreme Court. The Supreme Court recently granted review to the ATF's Frames and Receivers Rule case, which is known as Vanderstock versus Garland. The case is now set to be heard and decided by the Supreme Court during the court's next term. And even more important, now this case has the added benefit of the Supreme Court's recent ruling in the ATF Cargill case. The Supreme Court recently struck down the ATF's bump stock ban, and now the ATF's Frames and Receivers Rule looks like it's going to have the same fate. The Supreme Court has now set the arguments in the Vanderstock case to take place during October 8th, and the plaintiffs have submitted their arguments to the Supreme Court on why the ATF rule should in fact be struck down, why the Fifth Circuit's decision should be upheld, and also why the bump stock ban further supports that this rule by the ATF is improper. Now, to understand what's at stake in this case and why the Supreme Court's hands were forced to take this case, we have to talk about what has happened prior in this lawsuit and how it wound up in front of the Supreme Court. So originally in this case, the original plaintiffs, FPC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule while this case was making its way through the process. And on review, lower court Judge Reed O'Connor granted a limited preliminary injunction against the ATF, which prevented the ATF from enforcing the rule against Tactical Machining and its customers. Looking at that ATF rule on frames and receivers, he found that it was invalid, that it was not in line with the plain text of the statute, and that the ATF engaged in overreach. Now, after that, there were other companies like Blackhawk Manufacturing Group and 80% Arms who joined to be plaintiffs in this lawsuit because companies like 80% Arms, I'll tell you guys because I've had conversations with them, they've been hit very hard by this rule. You know, they're struggling. They've had to, I believe, get rid of some employees. They just had a lot of issues because of this ATF overreach, directly attacking their company, attacking their products, and trying to regulate them through essentially overreach. So when the plaintiffs like Blackhawk Manufacturing Group or 80% Arms joined this lawsuit, they were able to get the same type of limited protections for their company and their customers. Now, after that preliminary injunction stage, some of the plaintiffs sought to win the entire case, and they asked for a motion for summary judgment. And in response, Judge Reed O'Connor did grant the motion for summary judgment in favor of the plaintiffs, and he vacated the entire Frames and Receivers Rule. So this was a huge win because the judge struck down the entire rule and found that it was invalid. But of course, the ATF was not going to let that sit, so they appealed that summary judgment up to the Fifth Circuit. At the same time, the ATF sought for a stay of that. It was denied by both Judge O'Connor and the Fifth Circuit, and that led the ATF for the first time to go to the Supreme Court on an interlocutory emergency basis, asking for the Supreme Court to reverse what the lower court said, essentially asking for the Supreme Court to allow them to put in force and effect their Frames and Receivers Rule still, despite what the lower court said. And ultimately, on a decision, a 5-4 decision, the Supreme Court agreed with the ATF and stayed the enforcement of that summary judgment decision, which vacated the rule nationwide. And in that 5-4 stay order, Justice Barrett and Roberts were the ones who joined the liberals to decide in favor of the ATF. But ultimately, also what happened is that you had some of the plaintiffs, like 80% Arms, who decided to go back down to Judge O'Connor to try to get back the limited protections because, again, their businesses are being impacted by this rule. And they wanted Judge O'Connor to put back in place those limited protections so they could still sell and market and, do what they needed to do for their business. And of course, on review, Judge O'Connor, because he's awesome, granted the limited protections. He put back in place the limited preliminary injunctions, which would only protect, those companies and those customers. But again, the ATF went crying up to the higher courts. They asked for Judge O'Connor to stay that. They asked for the Fifth Circuit to stay that. Both were denied. And then they went to the Supreme Court for a second time on an emergency basis and said, look, the lower court judge there, Judge O'Connor, is defying what you guys said. You guys said that you were essentially going to put on hold the nationwide vacatur. They went back down to Judge O'Connor. They got limited relief. They're trying to circumvent what the Supreme Court said. They're trying to circumvent what you guys are saying. And therefore, Supreme Court, you should strike down that new judgment as well. And on review, once again, the Supreme Court sided with the ATF and struck down even that limited injunction from being put back in place. And because of that, the Supreme Court really prevented any positive relief in this case from happening while these summary judgment, proceedings were taking place in the Fifth Circuit. Now, ultimately on review, the Fifth Circuit recently did decide on the merits of the case, and in their decision, the panel partially upheld what the lower court decision said, essentially what struck down the ATF's rule. But the Fifth Circuit had to take into account what the Supreme Court had also said about nationwide vacatures. So they found issue with Judge O'Connor issuing a nationwide vacature of the rule, but still it was a win because they found that the ATF's rule was in fact a violation. It was an overreach, but simply they were sending the case back down to Judge O'Connor for him to decide, what more limited form of relief should be granted. But the ATF didn't even like that because they knew ultimately that would mean that their rule would be found invalid. So then they were forced in a very hard position and they had to seek Supreme Court review on the merits of this case. And that's where this current case is. Now you have the Supreme Court who has granted review to the final merits review of the ATF's frames and receivers rule. And right now it is set to be heard and argued on October 8th. Now, in their petition to the Supreme Court, the ATF really made the same fear-based ghost gun arguments that we've heard them make before, not just in the lower court, but in other circuit courts as well. They simply argue that the regulation is so important to essentially track firearm sales and to avoid criminals skirting the law and getting these so-called ghost guns into their possession. But now the plaintiffs have filed their brief in support of the Supreme Court striking down the 80% rule and upholding what the lower courts said. Now, in their brief, they once again argue that the ATF is engaged in overreach. They argue that the ATF is essentially trying to expand the definition of what a frame receiver is in the definitions of the GCA, and that they're trying to include items like precursor parts and parts kits that were never intended to ever be included in the definition of what an actual firearm is. Because again, when you look at this rule from the ATF, what they did is they said a bunch of parts kits, things like that, can actually be considered a firearm in their own right. Even though they're just a bunch of parts, they can be considered an actual firearm. Now, there's also a lot of interesting discussion in this brief, which is essentially pushing back against the ATF's position that they've always considered these parts kits or these 80%ers to actually be firearms. The ATF argues that their position has been consistent over the years. They've never changed their definition, that they always considered these items to be included in that definition, but we all know that's not right. There's been prior guidance which says the exact opposite. And what the ATF did with this rule is they put the rule in place and then they just wiped out all the other guidance that they had. They did not grandfather it in. Essentially, they tried to say, similar to what they did with pistol braces, that whenever they had guidance on a specific item, it was only referencing that specific item. But their general policy was that all these items, of course, were included in the definition. It's very convenient because they say, these were limited guidance on specific items, but we had a broader policy that we are now just clarifying with this final rule. The plaintiffs state in their brief that the argument that the ATF's position has remained consistent also is contradicted by ATF's repeated statements that the rule was necessary to address the urgent public safety and law enforcement crisis posed by the exponential rise of untraceable firearms and by the ATF's express refusal to grandfather in its prior classifications of any partially complete, disassembled, or non-functional frames or receivers that the ATF did not classify as firearms, frames, or receivers as defined prior to the rule. So what really the plaintiffs are arguing here is that the ATF is kind of talking out of both sides of their mouth. The ATF says that they've always regulated all these items as actual firearms, that they've always been included in the definition. And they also say then, on the contrary, on the flip side, that they created this rule to address public concerns in the rise in crime. So the ATF is trying desperately to save their frames and receivers rule. And after the Cargill decision, I think it's going to be very hard for them. Like I mentioned, right now, the oral arguments are set to take place in front of the Supreme Court. This is a final merits case, and it's happening on October 8th. So we're going to be looking forward to October 8th. It's going to be very interesting to see how the ATF and all the parties address this in front of the Supreme Court, and it's going to be interesting to see what the Supreme Court's general temperature is on this specific issue. So if anything else changes, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of toy news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.